Hey, this is Drew Page. Welcome to the Drew Page channel. In this video, we are going to talk about suing Elon Musk. And Elon Musk has been all over the news lately with this Twitter stuff that he's got going on. And we're going to walk through the development that led up to the lawsuit and where we're at today. I hope you found this video helpful. If you do, please subscribe to the channel. And I want to thank all of you so much who have subscribed to the channel and hung with me and continued to watch the videos and comment and share. I love hearing your feedback. So thank you to all of those who have subscribed. And if you haven't subscribed yet, please go ahead and hit that subscribe button and like the video and hit the notification bell. And with that, we'll jump right in. So over the last couple of weeks, Elon Musk has had a very busy time with Twitter. So it started off on April 4th when we were informed that he had filed with an SEC a filing indicating that he had taken a passive stake in the amount of 9.1 to 9.2% of Twitter stock, making him the largest shareholder of Twitter. Now, I did a video on this and noted that it was very unlikely that he would stay a passive holder of Twitter and that eventually he would likely file to take some sort of control. And it didn't take long. It was basically the next day he was filing the correct filing for an active investor. And the reason is because he had decided that he was going to be accepting a seat on the board of directors of Twitter. And so there was a big to-do about that with him adding that in. But then apparently there was some disagreement between the way that he was communicating about Twitter and the current Twitter board. And according to the CEO at Twitter currently, it was indicated that Elon had decided to step back and not take the board seat. And so everybody's like, well, what's going to happen next? Well, today it was announced that Elon has made an offer to purchase Twitter and make it a private company in the amount of $43 billion, basically increasing the stock amount. Or being willing to purchase it at an elevated stock amount, $50-some per share. So he is essentially trying to take Twitter private and away from being a publicly traded company. So that's the world that Elon has lived in regard to Twitter. Well, while all this has happened, there has now been a lawsuit filed against him. The lawsuit has been filed in the U.S. District Court for the Southern District of New York, and it was filed by the law firm Block and Leviton, and he's being sued for making a fraud on the market by either making material misrepresentations or omissions. And I actually have a copy of the lawsuit that was filed right here by the attorneys in the Southern District of New York. So just a brief summary of the information from the case is that they are doing a class action lawsuit, which means that they are taking people who are similarly situated and forming a class, because financially it wouldn't make any sense for just one person unless they had a massive stake to be an individual plaintiff and sue individually. So they're building a class to sue Elon Musk. And the class period is between March 24th of 2022 to April 1st of 2022. And the reason why they're selecting that date is according to SEC regulations, when someone takes a 5% or more stake in a company, they are supposed to file a form with the SEC letting people know that they have taken that large of a stake in the company. And essentially what the attorneys are arguing for the plaintiff is that had the investor known that Elon Musk had been purchasing Twitter stock and that he had taken such a large stake, that the investor would not have sold during that class period of time of March 24 to April 1st. So by March 14th, Elon Musk had acquired at least 5% stake according to the lawsuit, and therefore should have disclosed within 10 days or March 24th that he had taken that stake, and they're arguing that he didn't, that the filing was not made until April 4th when he filed the Schedule 13 notifying that he had taken a passive stake in 9.2%. So this class is seeking to represent all investors who had invested in Twitter from March 24th to April 1st. The other argument on this is that because it was not disclosed, Twitter price of stock was deflated artificially. So in other words, if it had been made known that he was the investor on March 24th, when it was supposed to have been done, the stock price of Twitter would have gone up then, and it wouldn't have stayed at its low level during that time period. Now, the lawsuit also claims that during this class period of time that there were material misstatements or omissions made. Now, it doesn't say where or when those things have occurred specifically with any specificity. So it'll be interesting to see how that plays out. I think that they're going to find that that's going to cause some difficulty at some point in the future based on other suits of this kind, but we'll see how it plays out. Put in the comments what you think. I mean, I've done a couple of videos where people are suing Zillow, people sued Grant Cardone, and it hasn't generally ended very well when you don't put the level of specificity. And even sometimes when you put the level of specificity, but there are other defenses to assist investors of this kind. So it'll be interesting to see how this plays out. Let me know in the comments what you think. So the primary suit is for fraud on the market, and it says that defendant made public misrepresentations or failed to disclose material facts during the class period. The omissions and misrepresentations were material. Twitter securities traded in efficient markets. The misrepresentations alleged would tend to induce a reasonable investor to misjudge the value of the Twitter security. And plaintiff and other members of the class sold Twitter securities between the time defendant misrepresented or failed to disclose material facts and the time that the true facts were disclosed without knowledge of the misrepresented or omitted facts. And then it talked about how Twitter is an efficient market because it was operating as it should. It was giving public disclosures, it was having conference calls, it was having regular communications with investors. So it was essentially saying that Twitter was operating like it should have, so it's not Twitter's fault, this is all Elon Musk's fault. They do not request any specific amount of compensatory or punitive damages. They simply ask in the prayer for relief that they be awarded those. Clearly, there's no way for them to know at this precise time how much they are going to be suing for because they're building a class, and so it will all depend on the nature of the class. And as you'll see from the certification by the initial plaintiff in the complaint, you'll understand why it's necessary for this to be a class. They also demanded a trial by jury to all issues that are triable by a jury. My guess is that there will likely be a Rule 12b-6 motion, which is a motion to dismiss for failure to state a claim upon which relief can be granted, which essentially means that the complaint doesn't state a cause of action where these people are going to win. That's going to be likely the first step, and then if the court denies that, then they will file an answer and other defenses. The complaint is signed by Jeffrey C. Block, who is from Block and Leviton, and there's also Jacob A. Walker is also a co-signer, and it says pro hoc vice to be filed, which means that they're not licensed in that jurisdiction, but they are waiving in through a local attorney. That's what pro hoc vice means. Now, the interesting thing is this particular plaintiff has to certify the nature of the suit, what Twitter stock that he actually sold, and on the last page it shows the amount of stock that he had purchased and at what prices. So on March 25th, which was within the class period, he sold 5 shares at $39.10 a share. On March 28, 2022, he sold 25 shares at $38.9806, and then on March 29th, he sold 5 shares at $40.6001. So he sold 40 shares during this time frame. So we're talking about if the stock price was elevated even to $60, just to round it off, when you're talking about 40 shares, the difference between the initial price and the price that it would have been for this one plaintiff is not going to be all that significant in the whole scheme of things. So they need to build a class to make it worth the value, because number one, a lawyer's not going to take a case like this. It's going to need to have more clients available, especially not in a federal lawsuit like this. So they have to build a class of people to be able to have sufficient amount of money to be able to do that. So it'll be interesting to see how this progresses. I'm sure there will be a quick and rapid response by Elon Musk's attorneys, and there'll probably be a filing there. So I'll keep an eye on this. If anything interesting happens with it, I'll be sure to do a video on it. Again, if you found this video helpful, please subscribe to the channel, like the video, hit the notification bell, and until next time, stay tuned.